I want to welcome you all here today. I'm Debray Weintraub, and I'm the supervising judge of the civil courts for the Los Angeles Superior Court, and I want to welcome you all here today. Today's meeting is to address civil e-filing. As you may know, the court is transitioning from paper to e-filing for all civil documents. There is a phase-in period, but mandatory e-filing will be with us on January 2nd, 2019. That means all litigants that are represented by attorneys will need to e-file civil documents. The main exception, of course, is for pro se litigants. You're going to be hearing from a variety of speakers today that will provide you an overview, including what it means to e-file. How does it work? And what do you need to do? We have electronic filing service providers in the next room and outside, and they're here to answer your questions. At this time, I want to thank our sponsors, the Consumer Attorneys Association of Los Angeles, the Association of Business Trial Lawyers, the Los Angeles County Bar Association, the American Board of Trial Advocates, and the Association of Southern California Defense Counsel. We thank you all. At this time, I would like to introduce Judge Kevin Brazil, our presiding judge-elect of the Los Angeles Superior Court.
Well, good afternoon, everyone, and thank you so much for being here. What a wonderful turnout. So we are delighted to be at this stage where we can talk to you about e-filing and some of the things that we've been doing. Our court has been going through this technology revolution now for a few years, and this is kind of one of the crowning achievements for us in getting to civil, where we can have e-filing, and we've got a new case management system. So we're really excited. We're going to give you a lot of information today. We also want to thank you for all of your patience. It's been taking us time to do this, but we want to make sure we do it right. So we've taken our time. We've been very deliberate. We've learned how to do it better just by introducing it to some of the other disciplines. So you're going to get a lot of great information today from a lot of our staff, and we have some of our staff here. So I'm very proud to say that this has been a team effort for the LA Superior Court. And we're doing it for you, we're doing it for your clientele, and we're doing it for our community. And it's almost here, and we're very excited. So I'm going to let Judge Buckley give a few comments.
Great, thank you. I cannot make one promise today. I cannot promise you'll see the beginning of the Dodger game. So I don't know what else to say, but if anyone is looking at their phone, I can understand why you're doing that. So I'm going to start off with some of the substantive issues. Many times when we move into something like this, and inevitably we will have a local rule. But we're going to start off as we have in the other disciplines, and if you do probate in your firm, you'll know exactly what we're talking about. But we are going to issue a general order, sometimes referred to as a presiding judge order, and that will be on the website, available immediately for you to review. And we will be covering almost all of the details in that general order, but it will be what governs the processes, deadlines, et cetera, et cetera. So that is available up on the website. Not by us, but by the California Rules of Court. We are allowed to mandate e-filing for everyone not represented except for a non-represented individual. So again, you'll see in the various calendars and so forth, we will have mandatory e-filing ultimately for everybody by January 2. And we are allowed to do that by the code. Also within the rule of court. Also within the rule of court, if you e-file, you must e-serve. If you e-file, you must e-serve. So obviously the deductive reasoning is once we mandate e-filing, you will have to e-serve to all of those in your case who are represented by counsel. If the self-represented litigant stipulates, then the self-represented litigant can be part of the e-service. I'm going to let the people that really know this system to really talk about how that process is on that. The experience in other courts is that self-represented litigants participate in e-filing and ultimately e-service more than you think, but again, we cannot mandate that. Let me talk about ex partes. Again, if you are working in the probate world, you are experiencing this as you sit there. The rule is that you have to give notice to the other side of an ex parte application by 10 a.m. the day before. What we are going to order now is that you must file your moving ex parte papers by 10 a.m. the day before. So at the same time, you are, the judges are going, yeah. The rule of court cited there, 3.1206, states that service of the ex parte must be at a reasonable opportunity, at the first reasonable opportunity. But, again, you'll hear from those that go into the details, you're going to be dealing with the EFSP, electronic filing service provider, who will be filing for you and hence serving for you. So that service of the moving ex parte papers will in all likelihood be by 10 a.m. the day before the hearing. An appearance is still required with the proposed order on the day of the ex parte. The rules will go into the opposition and so forth, but if you're going to e-file the opposition to the ex parte, you must do so by 4 p.m. We'll go into later as to issues of courtesy copies. If the opposition is filed after 4 p.m., then you will need to bring a courtesy copy to the courtroom the next day. The courtesy copies shall include the proof of electronic submission. As it is now, the opposition may be filed up to 8:30 a.m. And again, the attorneys shall e-file the opposition. When you get into the details of the general order, you'll see that if anything within 2 days, you need to provide a courtesy copy. So even though you may be e-filing that opposition at midnight or at 6 a.m., you still would need to bring a courtesy copy to the courtroom. So those are the things that we thought would sort of deal with the judge and so forth. We're about ready now to turn the fire hose on. Let me introduce someone who seldom needs an introduction, Sherry Carter, our Chief Executive Officer.
Oh, thank you. So a few of you stopped me because you recognized my name as being the executive officer when we mandated e-filing in the federal court. How many of you e-file in the federal court? So do you know the differences? Let me explain a few of the differences between the systems. In the federal court, you can e-file directly with the court. In the state court system, you use an electronic filing service provider. And that makes it, quite honestly, easier for you, I think. You don't have to go through that online process that you did on the federal system to get a login and a password. The electronic filing service provider will do that for you. We have made arrangements. We have several EFSPs that are in the room that you can go talk with, and they offer different services, and that's why we arranged for them to be here. And Snorri will talk about that in a little while. Another change that is a big difference between the federal system and the state system is when you file in the federal system, it automatically becomes filed when you submit it. In the state system, it goes into a clerk electronic inbox for review. You get a notice when we receive it, and then you get a notice when it's filed. So those are probably the two biggest changes between the two systems. And we're going to have a question session at the end, so if you have any questions, we'll certainly be happy to answer those. And I see some of you using your phones to record or to make copies of the screens. We are going to actually put a copy of this on our website, so if you need to refer to it, you can refer to it later on.
That got as many claps as the Dodgers. That's pretty good.
Yeah, okay. So in the system, we will be using filed and received ribbons that those of you who file in the federal system will be a little bit more used to, but they are different for the state court system. We're going to have a filed ribbon at the top. So the file stamp that you're used to will become a ribbon at the top. It still includes all of the statutorily required information, but it will be a file stamp at the top. That means for those of you who have not converted your files into an electronic file, if you still use a 2-hole punch, you just cut through the file stamp. That was the biggest complaint I heard when we went to that stamp, so I'm warning you now. If we receive a document, if it's not filed but received, like a proposed document, the ribbon will be on the side of the document. And then when it's filed, the ribbon will then go on the top. Filings received up to 11:59 p.m. will be deemed filed on that day if they are accepted for filing, because remember, they go into an electronic inbox for review. If they're rejected, they'll be returned to you with reasons, but if they're filed, it will be filed as of the date we receive it. If a signature is required under penalty of perjury, remember that the declarant must sign a printed copy and you need to retain it for inspection, and that's under California Rule of Court 2.257. And I just want to give you a heads up that as we go into mandatory e-filing and all of our records become electronic, we will then deem the official record of the court our electronic records. And when that happens, all of our certifications will be done electronically. And we have a letter for those of you who try to record things in other states, or if you need to register something with a bank. We do have a letter that will assist you, that will provide if you run into someone who does not like to accept the electronic certification. We ran into some of those snags both at the federal court system as well as when we implemented e-filing and probate. We've worked them all out with probate. I think most of the banks and the organizations now understand that we're going to be doing it electronically, but I wanted to give you a heads up so you can start thinking about those agencies that you work with. We are really excited about our e-filing schedule. You can see it's very aggressive. As Judge Buckley mentioned, we will be e-filing in everything civil except for the self-represented litigants who elect not to e-file by January 2nd. So you can see we have a voluntary date for limited civil. We want to get a little bit of experience, work out if there are any issues or questions. We want a little bit of time to work that out. Unlimited will be voluntary December 3rd, and then mandatory for limited will be December 3rd when we have unlimited voluntary, and then both unlimited and complex will become mandatory January 2nd. So we are very excited about that, and I will now introduce Nori Ogata, who is our Chief Information Officer, and he's going to explain a little bit more about the process.
Hello, everyone. Hello. Okay, so for civil, behind the scenes, we're using a vendor called Journal Technologies. They are our vendor of the court's case management system, and they are also our e-filing management vendor for the civil side. And for those of you that practice in other case types, we have a different e-filing manager on probate, family law, and those litigation types, just so that my job is secure in the future. Okay, so why...
Snorri. No.
Okay, why e-filing service providers? So the quick and short answer is it's basically because this is the only way we can mandate e-filing, right? The court rules as articulated state that the court must offer e-filing through one or more e-filing service providers. So the court could build this capability on our own and we could offer this service to you, but honestly at the end of the day the court's core competency isn't about writing software, it's about providing services to the administration of justice. So we find partners like Tyler in the civil arena to help us make that possible, and then through an external network of providers called e-filing service providers. What's it? Journal. Sorry. Sorry. Okay. All right. So what is e-filing? How does it work? Really, it's very similar to the paper-based world, right? That just the players are slightly different on how things move around. So there's you. Everything starts with you as the customer. You prepare the files and get them ready for submission, and you have them submitted to the court. So now instead of having an attorney service firm or a courier come and bring those documents to the court along with the payment, right, you're going to use an e-filing service provider. The e-filing service provider gets the cases basically ready and the information ready for clerical review. So the e-filing manager, the EFM in that middle box there, is essentially the equivalent of an electronic clerk. So that's the system where the documents submitted are stored, where the court clerk reviews, and then upon acceptance, it moves it downstream and into the court's case management system. That's also the point in the process where if it's rejected, you'll get a notice back through your EFSP of the rejection. Okay, so the good news is that there are going to be lots of choices for e-filing service providers. So right after this presentation concludes, I think it's right behind us, there's a room where the first 15 or 20 or so of these vendors are going to be telling you a story. Over time, that list will probably go to 40 or 50 companies that provide this service. 61 companies, okay. So a lot of people are vying to do your business, and choice is good if you believe in free markets. So they will be able to tell you a story of what they do and how they do it. The list of the current e-filing service providers will be available on the court's website. So I would encourage you to look there often and check so that you can see if anybody new has entered into the marketplace that you might be interested in. One of the benefits of e-filing is you will create a user ID that's transportable. So if you decide that you want to switch from one vendor to another, your identity credentials will be preserved and maintained. But really, I guess my biggest piece of advice is after this session is over, go next door and talk to the e-filing service providers so you can see how they differentiate themselves in the marketplace. Okay. So the LA website will feature prominently in where you go to look for all things e-filing. We like to give you lots of doors to find the information you want, recognizing that people search for things differently, but we try to make it simple. So look for that little chevron shape with an E in the middle of it to indicate that it's e-filing. So you can find the e-filing information straight from the court's homepage by clicking on the e-filing link. If you're a little bit more orthodox and deliberate in your searches, you can choose to go to the website and then choose divisions and then choose civil and then choose e-filing. But I would personally just go to the e-filing link. And when you land on that page, you'll land on that little window that's in the middle, sort of on that page there. That'll have useful information. It'll have links to frequently asked questions, links to the current e-filing service providers that have been certified within our environment, and a list of the documents that are allowed to be e-filed. So definitely encourage you in the beginning especially to check there often. Okay, a few other tech things. PDF is the official format for the electronic court record. So if you're creating documents in Word, which most of you do, and there's still a few out there that use WordPerfect for some strange reason, you can save those documents as PDF, and that will preserve the searchability. This is really important because the court research attorneys and judges like to do text searches on the documents, just like you do. And if you scan the document, you basically turn it into a picture, and it's very hard to search text on a picture. So that's the first requirement. For proposed orders, the rules of court specify that DocX or Word formats are required for proposed orders, but we just like to be a little bit different here in the LA court, and it does allow us to also require it in PDF, and just so you know, we're going to use the PDF version, right? Over my objections, but she makes the rules. Okay, bookmarking and exhibits. So when you submit your document, if it has exhibits inside the context of that single document, you're required to put those bookmarks in there to facilitate ease for the judicial officers as they move through the document. And the same thing would be true for hyperlinking, right? So you can move through a document through bookmarks or hyperlinking. It's sort of your choice on how you want to implement them.
So Snorri, if I may interrupt, if you've dealt with the, I won't say the wrath, but a judge not being happy because you did not put tabs, let's say, on your submitted motions, that is now going to be the same reaction if you do not bookmark. And the best way to make a friend with your judge is to hyperlink. So we have to really emphasize bookmarks are mandatory, and the hyperlink will be a nice benefit.
Strongly encouraged.
Strongly encouraged. If you want your judge to love you, that will help.
I challenge that statement. I've been sending you lots of emails with hyperlinks, and I don't feel the love.
So many things to say, but
I think I'm going to move on to the next slide. Okay, a few more tech things. So you're going to learn a whole new vocabulary in e-filing, and so for us, there's this thing called a transaction or an envelope, and sometimes when you're calling to the court, try to get clarity, you did my document file, or I swear I submitted it, here's my envelope ID, what does that actually mean? So it's just a simple way of delivering electronically all of the documents that you're filing on a single case. And so that's the key. You cannot file multiple documents on multiple different cases in a single envelope, right? All of that information comes into the court, it's presumed to be part of one case, and it's going to get filed to one case. So if you send another document in there for a different case, it's going to be on that other case. So that's one key piece of information. So you're going to learn the vocabulary of transaction and envelope IDs, because that's the thing that you're going to use to troubleshoot if there's any question about the fidelity of the transmission. You will get a confirmation instantaneously from your e-filing service provider. When you hit the submit button to go in there, that indicates that they have effectively passed it over to the court via journal, so that it's ready for our processing. The court will return accepted and completed documents to you with the court stamps, file stamps on them. And typically the processing time is 2 hours to 2 days or more. The 2 days or more typically when there's something particular that requires additional research or signatures or things like that. But in general, the time frame is 2 hours to 2 days. And then the most important reason why the court implemented with e-filing service providers, because if you have a question about e-filing, you call them, you don't call me. I'm not staffed to provide that level of support, and neither is Denny on the operational side, right? The value of the partnership with the e-filing service provider community is that they provide training, they provide technical support, and other value-added services that you'll learn about when you go talk with them. So with that, I'd like to introduce Denny Butler, who is the Deputy Executive Chief Operating Officer of the court.
Thank you, Snorri. All right, so now that you're excited to e-file, I get to tell you about the things you can't e-file. They are peremptory challenges, trial and hearing exhibits. Those are the ones that you mark for ID, you submit as evidence, those kind of things, not the ones you attach that we talked about earlier about bookmarking and hyperlinking, not those. Bonds and undertakings, lodged documents, although we do want the notice of lodgement e-file, and documents that are for related cases. So for instance, if you have a civil case that has a probate case that's a related case to that civil case, you need to file the probate documents in the probate portal and the civil documents in the civil portal. So see, really it's a pretty short list of things you can't e-file. Initial filings. As Snorri said, the stamped document transmitted back to the filer via the ESFP will provide the information on the filing ribbon. A lot of this has already been covered either by Sherry or Snorri, so thanks for that, you two. Appreciate it. Hearing information will come back on the ribbon in some instances, but there will also in unlimited civil be a separate document that's a notice of case assignment, and it will have the judicial officer, the department, the hearing information, and that will come back with the filing as a separate document. Proposed orders will start out as received with the ribbon on the side, and will come back to you with the ribbon on the top once it's signed by the judicial officer and completed its process and docketed into our electronic case file. The submitting party will serve all of the other parties. Rejection reasons. E-filing is much like filing in paper over the window. The typical rejection reasons are the same types of reasons that your document would be rejected at the window. And they include picking the incorrect filing location, case type, not having enough money, saying you have a fee, indicating there's a fee waiver when there in fact is not, incorrect party type, illegible documents submitted, which doesn't happen quite as much with e-filing, and what Snorri mentioned, which is if you send us multiple documents for multiple cases in one envelope, we will reject all of them. So if you send us multiple documents for one case in one envelope, we can review those and process those. Courtesy copies, everybody's favorite. So Judge Buckley went over a little bit the courtesy copy requirements on ex partes. So this, what I'm about to talk about, doesn't pertain to ex partes. He covered that nicely. This is everything else in the world, okay? So e-file prior to submitting your courtesy copy to the court. Courtesy copies are required for any kind of document that is filed within 2 days or less of the court hearing. Include the proof of electronic submission with your courtesy copy. That's why you e-file first. The e-filer must submit the courtesy copy of the document when any, oh, I already did the 2 days, so sorry. And see, they already covered all my stuff. All right, more on courtesy copies. We need a courtesy copy of any printed document required pursuant to a standing or general order. For instance, the documents in a trial binder, when your case goes out to trial, those still need to be printed so that you can give the binder to the judicial officer that's going to be trying the case. Pleadings and yes.
You want to go to the next slide?
Oh, I'm sorry. Yeah, thank you. Pleadings and motions, including attachments, such as declarations and exhibits of 26 pages or more, require a courtesy copy. Pleadings and motions that include points and authorities, demurs, anti-SLAPP filings, motions for summary judgment and adjudication, and motions to compel further discovery. And just because we want to make it really fun, nothing in the general order, which will outline all of the things I just mentioned, precludes an individual judicial officer from requesting a courtesy copy of additional documents. So courtroom-specific courtesy copy information and guidelines will be found on our court's website under courtroom information.
And if I may, Denny, you will see that some judges will be saying no courtesy copies. So it will be good to look at that, and you might actually get some information from that individual judicial officer not to submit the courtesy copies. Otherwise, most are going to follow what Denny just listed.
As Snorri mentioned, we have a very long list of FAQs that will be posted on our website. They're being posted today, I believe, so you should be able to see them almost immediately. We will post the general order once it's all finalized, and there'll be a lot of other information on the website, including a video of this presentation once we edit it so that we all look marvelous. So hopefully you'll have, and this PowerPoint, so hopefully you'll have all the information you need. Vendors are on site, as Snorri said, and that concludes our presentation.